Here is something that surprises students. Federal courts can't just hear any case anyone wants to bring. Federal courts have limited jurisdiction. They can only hear cases that fall within categories defined by Article 3 and authorized by Congress. Understanding these limits is essential because jurisdiction, the authority of a court to hear and decide a case, is the gateway to everything. There are two principal bases for federal jurisdiction. The first is subject matter jurisdiction, cases involving a federal question, meaning a question of federal law, constitutional interpretation, or the rights and duties of the United States. The second is diversity jurisdiction, cases between parties from different states, where the amount in controversy exceeds $75,000, or disputes between state governments. By contrast, a case raising only state law questions between parties from the same state generally goes to state court. But even when a federal court has subject matter jurisdiction, several additional doctrines can still prevent it from hearing the case. These flow from Article 3's case or controversy requirement. Federal courts can only decide actual disputes with real parties who have concrete interests. They cannot issue advisory opinions on the constitutionality of laws that haven't been applied to anyone yet. This generates a cluster of threshold doctrines you should know. A case isn't ripe if the harm hasn't occurred yet and isn't immediately threatened. A case is moot if the harm has already been fully resolved and no live controversy remains. And a party must have standing, which requires demonstrating an actual injury in fact fairly traceable to the defendant's conduct that would be redressed by a favorable decision. The standing doctrine has been a significant tool for limiting access to federal courts, especially where the harm is diffuse, like a taxpayer challenging government spending, or where the causal chain is indirect. There's one more major limit, the political question doctrine. Courts will decline to hear cases involving questions the Constitution has committed to the political branches, or questions that lack judicially manageable standards. The most consequential recent example is Rucho v. Common Cause in 2019, where the court held that partisan gerrymandering claims present non-justiciable political questions, taking federal courts out of that issue entirely. Why does all this matter? Because these jurisdictional doctrines are not mere technicalities. They determine which disputes get into federal court at all, and therefore which conflicts the judiciary can resolve and which it must leave to the political process. Jurisdiction is, quietly, one of the most powerful tools courts have for shaping their own role.